Now we are discussing an important topic, IPO documents, including DRHP, RHP, Final Prospectus, and SEBI and Companies Act. Clear guide on IPO documents. Before a company hits the stock market with its initial public offering or IPO, it must go through a structured disclosure process. This journey unfolds in three key documents, that is, one is DRHP, draft red herring prospectus, and RHP, that is red herring prospectus, and finally the prospectus. These documents are more than just paperwork, they are legal disclosures designed to inform, protect, and guide investors. In today's video, I will explain these documents, their legal framework under the Companies Act 2013 and SEBI's ICDR regulations, and the consequences of misstatements or false information. What is IPO and the role of the prospectus? An IPO, initial public offering, is a company's first offer of shares to the general public. Under Section 23 of Companies Act 2013, a public company can raise funds from the public to a prospectus, while a private company must merely rely on rights issue or board issue. What is prospectus? According to Section 25 of the Companies Act 2013, any document inviting the public to subscribe to securities is treated as a prospectus. It is the backbone of the IPO transparency. It outlines business details, risk factors, financial health, and management. And many more details will be there in this prospectus. What is DRHP? Draft red herring prospectus. This is the first formal document filed with the SEBI by a company planning an IPO. Think of it as a semi-finished blueprint of the company's intention and business story. It includes overview of the company and its business, financial statements, risk factors, management team details, legal proceedings. These are all the details will be there in the DRHP, draft red herring prospectus. So here missing is price of the shares and number of shares to be issued. Those are finalized later. So the SEBI ICDR Regulations 2018, particularly Regulation 6 and Regulation 7, governs the process of DRHP filing. SEBI examines the DRHP for completeness, accuracy, and regulatory compliance. If it falls short, then the issuer must rectify and refile. So the goal is investor protection through transparency. Now, what is RHP, red herring prospectus? Once the SEBI gives its nod, the company files the red herring prospectus, that is RHP, a more refined version of DRHP. It still does not include the final share price or allotment details, but it is far closer to the final form. Under Section 32 of the Companies Act 2013, the RHP must be filed at least 3 days before the IPO opens. And a red disclaimer on the cover warns investors that this is not the final offer document. This red herring prospectus, that RHP, includes price, that is a price band for the IPO, updated business and final data, use of IPO proceeds, legal and statutory disclosures. So the RHP builds investor confidence and sets the stage for price discovery during the book building process. What about final prospectus? The final stage is the prospectus, the legally binding document issued once the IPO price and allocations are locked in. At this point, all blanks from the RHP are filled. The prospectus includes final share price, number of shares issued, subscription and allotment details. So it is the last official document. This is the last official offer document issued to the public. Earlier, Section 26 of Companies Act 2013 mandated a specific contentions in a prospectus. Now, the focus has shifted to Schedule 6 of the ICDR Regulations, which lays down what the document must include: cover page, table of contents, risk factors, capital structure, legal proceedings, financial statements, management discussion and analysis, regulatory approvals, statutory disclosures. And these are all this document which should contain. These are the details. Legal consequences if there are any mismanagement or misstatement. Legal consequences of misstatement. What happens if the information disclosed in any of these documents is false or misleading or deliberately omitted? Then Section 34 of the Companies Act deals with the criminal liability for fraudulent disclosures in prospectus, and Section 35 provides civil liability, including the right for investor to seek compensation for losses caused by the misleading statements. And Section 447 prescribes punishment for fraud, including imprisonment. Those who may be held accountable include directors at the time of the issuance, promoters, persons authorizing the issue, experts like auditors and valuers. There is a landmark case, Kimsu Krishna Sinha versus SEBI. The Delhi High Court directed SEBI to act against the DLF and its CFO for not disclosing critical information in their DRHP and RHP. As a result, the directors were barred from the securities market for 3 years. So this shows how seriously courts and regulators view disclosure violations. So the conclusion is the IPO process is built on the foundation of layered disclosures. Each document, DRHP, RHP, and prospectus has distinct role in helping investors make informed decisions. DRHP gives a draft view, and RHP brings in regulatory verified details and price band. And the final prospectus seals the deal with the pricing and allotment. Behind these documents is a strong regulatory framework, that is SEBI's ICDR regulations and the Companies Act 2013, designed to protect investor interests and ensure market transparency. So if you like this video, please do subscribe. We have 2 channels, RR Corporates and RR Legal Talks. Hit the bell icon so that you will not miss any of the latest updates. Thank you.